Kesavananda Bharati Case. Kesavananda Bharati Case 1973. This we will discuss in detail when we will be discussing fundamental rights. But as of now, in context of preamble, certain things happened and the Supreme Court given certain observation in this very famous case in Indian political history. So what happened, there were various suits filed against various amendment made by the government of India, or the parliament rather. After 1950, a series of land reforms and related laws were made. Some as per constitution and some were definitely inconsistent to the Article 19(1)(f) and Article 31, which deals about the right to property. So the people, they were going to high courts and Supreme Court, and the high courts in India, they were giving different decisions. So there was a confusion related to the land reforms laws and what the rights of individuals are. Are the high courts were in position, or really they were protecting the right to property, or there was some overlapping in various decisions of the high courts, some in contradiction and some in tandem. So there was a bit of confusion. So what Supreme Court did, it clubbed all the former cases, all the former similar cases in Kesavananda Bharati case, and a 13-bench judge given a verdict, and they have established the doctrine of basic structure 7:6. But what was the actual case? The actual case was, there was a mutt in Kerala, and the priest Kesavananda Bharati ji, his lands were acquired by the Kerala government, because in Kerala a law was made in 1963, the Kerala Land Reform Act, and the same was amended in 1969, and this amendment was legalized through 29th Constitution Amendment Act 1972. And now this 29th Constitution Amendment Act 1972 was placed in Schedule number 9. So I guess you are aware of the fact that if a law inserted in Schedule 9, then it is beyond judicial. It is beyond judicial review. Until 2007, this was the case. Still it is, barring some exception, Article 14, 19 and 21. So when 29th Constitution Amendment Act was made, then the land acquired by the Kerala state of Kesavananda Bharati ji, that mutt, then it became a matter of concern that to what extent the parliament can amend the constitution. Is there any restriction on amendment? Or the restriction, the amendment power the parliament has, it is unparalleled, unfettered, unrestricted, unlimited. This was the basic question. So Supreme Court clubbed all the similar cases which they have previously held and heard. It was 17th Constitution Amendment Act, 24th Constitution Amendment Act, 25th Constitution Amendment Act, and finally 29th Constitution Amendment Act. तो इन चारों अमेंडमेंट को एक बार ही उन्होंने कहा कि नहीं लाओ, सुनते हैं फिर से, क्योंकि कंफ्यूजन सा क्रिएट हो गया था पूरे इंडिया में कि एक्चुअली होगा क्या चाहिए. फंडामेंटल राइट्स इंपॉर्टेंट होंगे कि डीपीएसपी इंपॉर्टेंट होगा, कौन सा कंसर्न होगा, नहीं होगा, पार्लियामेंट को क्या पावर है. तो देयर वाज एन एडवोकेट नानी पालकीवाला. He represented Kesavananda Bharati ji in this case, and he given a very wiseful, logical, rational argument. And he said, "Ki, my lord, do the parliament has unparalleled power to amend the constitution? Second, if yes, then will it be amendment of the constitution or something like rewriting a constitution?" And he then argued that we believe there are certain values, elements, features, pillars, ingredients of the constitution which cannot be subjected to any amendment, which shouldn't be subjected to any amendment. And he then quoted Preamble. He said Preamble contains a group of basic element, features, pillars, values which we believe cannot be amended in any case. And he then referred these elements as basic element and said the parliament shouldn't be allowed to amend anywhere in the constitution. There should be some limitation, restrictions on the parliament's amending authority. इनकी बात को सुना, डिस्कशन हुआ, 7-6 से डिसीजन आया और सुप्रीम कोर्ट ने कहा बात आपकी सही है. We also think that there are certain elements which cannot be altered, amended. हम ये मानते हैं. और उसी को कहा उन्होंने द बेसिक स्ट्रक्चर डॉक्ट्रिन यही है. लेकिन नानी पालकीवाला की एक बात को नहीं माना उन्होंने. क्या बात? नानी पालकीवाला ने कहा था कि अमेंडमेंट पर रिस्ट्रिक्शन होना चाहिए. द सुप्रीम कोर्ट से नो, द पार्लियामेंट कैन अमेंड anywhere in the constitution right from article 1 to article 395, but whether the amendment is in accordance to the constitution or not, it is the Supreme Court who will decide, and the reference will be the basic structure doctrine. So we cannot restrict the parliament to amend the constitution, but we can definitely check, review, examine whether these amendments are in accordance to the constitution or not. बात समझ में आ गई? तो दोनों का एक मिडिल पाथ निकाला गया. कर भी सकते हैं, लेकिन जो आप करेंगे वो फुल एंड फाइनल नहीं होगा. हम चेक करेंगे कि आपने जो किया है वो कहाँ तक सही है और कहाँ तक सही नहीं है. और अगर हमें लगता होगा कि ठीक है, नहीं, नल एंड वॉइड. तो जुडिशरी ने एक ऐसा डॉक्ट्रिन दे दिया जो कि अब सब्जेक्टिव हो गया. बिकॉज बेसिक स्ट्रक्चर nowhere is defined in Constitution of India. It is only established by some court decisions, Supreme Court decisions, and it is not an exhaustive list. Things will be added, and by doing this, the Supreme Court has given a power to itself. They can look into the subjectivity, the content, the matter, the subject matter of a law. They will not only look into the procedure, but they also will look into the content. They also will look into the output of a law. जो लॉ बना रहे हो, क्या वो लॉ ठीक है? समझ में आ रहा है? तो केशवानंद भारती केस 1973, इसको हम डिटेल में पढ़ेंगे जब पढ़ेंगे फंडामेंटल राइट. तो ये केस बेसिकली था 29th कॉन्स्टिट्यूशन अमेंडमेंट एक्ट को लेकर. 29th कॉन्स्टिट्यूशन अमेंडमेंट एक्ट 1972. What happened in this? Kerala Land Reform Act. Kerala Land Reform Act It was inserted in schedule number 9. So Kerala Land Reform Act, it was inserted into schedule number 9, and this was challenged by Kesavananda Bharati ji in Supreme Court. So there were 3 questions. What is the constituent power of Parliament to amend the Constitution? What is the constituent power of Parliament to amend the Constitution? Second, is it limited or unlimited? And third, there are some basic elements in Constitution that shouldn't be amended. तो सुप्रीम कोर्ट क्या कह रहा है? सुप्रीम कोर्ट ये कह रहा है कि we believe that the preamble is a part of Indian Constitution, or not only they are believing, they are declaring this. Why? Because it was a part of original judgment. So preamble is a part of Indian Constitution. And why they have said this? Because the Supreme Court in 1973 said that the decision made by the Supreme Court way back in 1960 in Basic case, it was wrong. Why? Because the Constitution Assembly procedures were not taken into consideration. Because the Supreme Court is saying the Constitution Assembly has accepted the preamble in a same manner, under same procedure, as it has accepted the other part of Constitution, means article, parts and schedules. So if these are under the same procedure and manner, are the part of Constitution, so why, if preamble is accepted through the same manner, why it is not a part of Indian Constitution? So this interpretation or the fact of the law was not interpreted then in 1960. So Supreme Court is now saying that the decision given by the Supreme Court in 1960, Basic case, it was wrong. And they have rectified that in 1973 by declaring that preamble is a part of Indian Constitution. Now, there might be another question. Whether the Supreme Court can change decision of High Court? Yes. Of its own court? Yes. But the only requirement is the bench should be larger than that of the earlier bench. Then only they can override a decision given by a previous bench. So in Basic case, I guess it was 7 judges case, and Kesavananda Bharati case, 13 judges case. तो बड़ी बेंच है, बड़ी बेंच छोटी बेंच को के डिसीजन को ओवरराइड कर सकती है। बात क्लियर हो गई? तो 1973 में सुप्रीम कोर्ट ने कह दिया जी प्रिएम्बल कॉन्स्टिट्यूशन का पार्ट है, ठीक, और नेचुरल भी है। When you go to purchase a book, the preamble is within that book. It is not कि it is some 4 or 5 pages extra additional, and the bookseller they will provide you, no, also take this 4 or 5 pages because it is preamble. The preface, forward, preamble, introduction, it is already a part of that book because it is within the book. Okay. So Supreme Court is saying that now preamble is a part of Indian Constitution. So originally it was declared that the preamble is not a part of Indian Constitution. But in 1973 the Supreme Court is saying no, preamble is a part of Indian Constitution.
अब एग्जाम की तैयारी को और बेहतर करने के लिए हमारे चैनल को लाइक, शेयर और सब्सक्राइब करना ना भूलें।